Hello and welcome to the very first episode of Heart of Employment. This is a show where we talk with California employment attorneys about your rights at work and everything your boss hopes you don't know. I'm your host, Dave, and today I am joined by California employment attorney Brandon Ruiz. Brandon, welcome to the show.
Thanks for having me, Dave.
Brandon, how long have you been an employment lawyer and why employment law?
I've been doing this for 16 years, and I started doing this because I wanted a way to help people out and channel the negative aspects of my personality into people I thought deserved it.
Yeah, you hear sometimes in the comments it's like, "Oh, we don't need employment law. If people just followed the rules, there wouldn't be a problem." But something I'm sure you've seen in your long career is companies are breaking the law all the time.
Oh, yeah, constantly. I mean, most companies are probably breaking at least some laws.
And just to touch on that real quick, do you think companies are breaking the law on purpose, or do you think they're breaking the law just because they don't know?
It's a combination. I think a lot of it is they don't know, but I think a lot of it is expediency. It's easier, it's faster to do it the shortcut way, and the shortcut way is usually the wrong way.
Right. And when you call them on it or when an employee calls them on breaking the law, do they put up much of a fight or they often say, "Yeah, we messed up and we're willing to fix it?"
I have rarely seen them say, "Yeah, we messed up and we're willing to fix it."
Right. Right.
They usually, give you the middle finger and fight.
Right. And you like that fight, and that's
I
why you're
do.
here.
Yeah, that's
Yeah.
right.
Let's jump right into it. What are the most common employment laws that you see companies break?
So in two broad categories, wage and hour is, pay type of stuff. The most common things you see are off the clock work, things like pre-shift work, post-shift work, transportation to and from your work site, bag checks, things like that. But also meal and rest periods, not being allowed to take your lunch break or your 10-minute rest breaks. And then on the individual side, it's more things like accommodation for disabilities because everybody has a right to work. And if your doctor gives you restrictions saying you can't do certain types of things, your employer has to try and work with you to let you continue to do your job. And a lot of employers don't do that very well.
Well, that's a lot. That's
Yeah,
so it's kind of runs the gambit
it sure
of
does.
yeah. When it comes to off the clock work, one important distinction is that's only for hourly workers, correct?
Yes.
So is there any limit if I'm a salaried exempt employee, is there any limit to how much my boss can work me?
Well, if you're actually a salaried exempt employee, no. But a lot of people who are paid salaries and are considered exempt are not, in fact, exempt or should not be exempt.
Okay. And with the off the clock work, sticking with that topic, one question we get all the time is I've gotten to work and I'm walking into the building, but I've had to park 5 minutes away. Should I be paid for that time it takes to park my car, then to walk into the front door of my job?
Generally, no. The test is whether you're under the control of your employer, not whether you're doing something to get to work. So if you could be dropped off in front of the building and just walk in, no. If you have no choice but to use their parking facilities and take a shuttle, maybe, probably.
So if I have to take if someone watching is taking a shuttle into their work every day, there's a good chance they should be paid for that time.
Yeah, that's right.
Interesting. Interesting. Okay. What are some dirty tricks companies do to try to hide their illegal activity?
A lot of times there's this thing called a cat's paw, and it comes from the idea of there's an old folk tale where a monkey is trying to get chestnuts off a fire, and so they convince a cat to knock them off the fire. The cat burns its paw.
Oh,
And
okay.
so cat's paw is when the person who has the bad motivation, the person who wants to, screw you, they don't actually do the bad thing. They have someone else do the dirty work for them. So maybe your boss goes to HR and then HR conducts an investigation with, information provided by your boss who doesn't like you for some illegal reason, and then HR fires you. So I think cat's paw is probably the biggest, most common way that they use dirty tricks to keep people out.
Okay, I did not expect you to say cat's paw. I've never heard that in my life. Okay, so let's just break that down a little bit more. So what you're saying is often companies to hide their illegal behavior go through HR.
Yes. Yeah.
And so you're saying HR isn't always your friend.
Oh, it very rarely is.
Wow. Okay. And so what are some red flags that an HR person may do that may make me think, "Uh-oh, they're trying to fire me?"
There's a lot of things that could be red flags in this scenario. I think probably one of the more common things you're going to see from HR that suggests that the writings on the wall is if they come into questioning or investigations of any complaints and they already kind of have a predetermined conclusion and it already seems like they've made up their mind before they come in. If they're asking targeted questions about why did you do this and why did you do that instead of what happened.
Mm, okay. And so what is an employee? So we do see that a lot in our like TikTok and Instagram comments of I went to HR and right away they're blaming me. They didn't even investigate. They're just saying you're wrong and you're going to be punished. What is an employee supposed to do in a moment like that?
Generally speaking, you answer the questions,
Yeah.
you take notes. I would all if I was having a meeting with HR and I was concerned I was going to be fired, I would be taking notes. I would ask for a witness to be present with me so that someone else can corroborate what happened. Because
Wow.
I've had a bunch of HR meetings where they just come back and lie later.
Really?
Oh yeah, absolutely.
And so, in order to prevent an HR person's lie from kind of ruling the day, you're saying it's notes, it's witness statements.
Yep.
What else?
I mean, you can record too. I mean, California is a two-party consent state, so you need to have everyone agreeing to you recording, but that consent doesn't necessarily have to be affirmative. You could put a tape recorder in the middle of the room, say, "I'm recording this conversation." If you keep talking, you're consenting, and that's probably going to hold up.
Wow. Have you seen cases where employees have done that?
Yes,
Wow. Okay.
but don't do secret recordings.
Right. That's the key. So, no secret recordings, but having that record can be crucial to winning an employment law case.
Yes, it can.
So, in an at will state, does an employer need a reason to fire you?
No, they could fire you for any reason or no reason at all. I could fire you because I don't like the color of your shirt.
How dare you? But I think what I find confusing about this, and a lot of people do, is you often hear, okay, if you think you were wrongly terminated, make sure you get a reason for why you were fired. So there's a little bit confusion, I think, as they don't need a reason, but if you take a company to court, they need to provide a reason.
Yes.
So where does that line land?
So, I mean, you always want to try and get a reason for termination. They don't have to give you one, but if you're suing a company and they say we fired you for no reason, that doesn't look very good. It doesn't make a lot of sense.
Right.
But really, what you're looking for is a changing explanation, because a changing explanation provides what we call evidence of pretext. That I'm doing the bad thing for a reason other than what I told you. So if I tell you, Dave, I'm firing you because I don't like your shirt, and then we go to court and I'm like, oh yeah, it's because Dave, messed up 17 reports in 3 days. That would seem like maybe I'm making things up and I found something after the fact.
Got it. And that term again was changing.
Sh- it's shifting explanations.
Shifting explanations. So if the company says, we fired you for this reason, and then a couple of days later, they're like, actually, it was this reason, that's a good sign that there's something fishy going on.
Yeah, that's usually a red flag that there's something off.
Okay, I want to get into a segment called Can They Do That? I'm going to ask you some questions, and you let me know, can the boss do that? So, can I get fired for calling out sick, even if I have a doctor's note?
Can you? Yes. Can you legally? Probably not. I mean, California allows you to take sick time, and you can't directly sue for that, but there are statutes you can use to bring a claim if you're fired because you're using sick time.
So, let's clarify. Can I be fired? So, let's take this in two parts. Can I be fired for using an earned sick day?
Not legally.
Not legally. All right.
You can be fired for whatever, but
Right.
not legally.
So it is illegal to fire an employee for using an earned sick day for medical reasons.
Correct.
Does mental health count as a legal reason?
Sure does.
Okay. Now, what if I'm out of sick days but have a doctor's note? Can the company legally fire me for missing work?
So that depends. If you're out of sick time and you don't have a specific medical condition, probably. If you have a specific medical condition and you request like FMLA or CIFRA leave, then no, they would have to give you what we call intermittent leave.
And CIFRA is the California Family Rights Act.
Correct.
Yes. And so that's an important distinction. If I have a medical condition that causes me to need accommodations, so perhaps I have chronic arthritis or something, and the company knows about it, they may need to give me time off as part of my accommodations. But if I just have the flu, the company's not necessarily legally required to give me time off if I don't have sick time to use.
Correct.
Interesting.
You can use other types of paid leave, vacation, PTO, if they allow you to do that, but that's really more of a company policy issue.
Okay, got it. Can my boss cut my hours from full time to part time?
Yes.
Is there uh is there any limitations to that?
Well, I mean, any sort of change in your work schedule like that couldn't be retaliatory. It can't be because you made a protected complaint, but most complaints are not protected.
So I just saw a question on our TikTok yesterday. They said if I work 40 hours, I get benefits. But if they recently cut me down to 30 hours, now I don't get any benefits. What am I supposed to do? What would you tell someone that called with a question like that?
Uh, if you're cut from full time to part time and you lose benefits, there's not really a remedy. There's nothing you can do about that unless it's for illegal reasons.
Okay, it's just companies have a right to cut your hours
At will.
at will. Now, do they need to give notice if they're going to cut hours or wages?
They have to let you know before it takes effect, but they don't have to give you like 24 hours, 48 hours, a week, a month. It's as long they can't retroactively cut you, but they can cut you moving forward.
I've heard that just a pay stub, like when I get my paycheck and it says now I'm making $17 an hour instead of $18 an hour, just the pay stub alone can be considered notice. Is that true?
Possibly, yes.
Possibly, yes. Okay.
Mhm.
So, yeah, and can my boss reduce my wages?
Yes.
Disappointing, but uh, there's no exceptions to that.
Again, there's always the exception of it can't be for illegal reasons, but if it's just because they feel like it or they don't have money or something like that, yes, they can cut your wages.
Bummer.
Yeah.
Okay. Now, if I quit without notice, can my boss hold my paycheck?
No, you are entitled to be paid for any work that you've done within 3 days of your resignation.
And does that 3 days include weekends?
It sure does.
It does. So if I quit on a Friday, company has to pay me by Monday.
Yeah.
And sometimes we get pushback that says, no, no, my company, it's on the next payday, but not in California.
Not in California. Every day that they don't pay you after that third day, they have to pay you a full day of wages at your regular rate for your regular schedule.
So, and if I want to get that penalty, do I go to an employment attorney or do I contact the labor board? What's the best way to get paid for those violations?
Either you can go to the California Labor Commissioner's office or you can go to an employment attorney. There's a cap of 30 days, so whatever your daily rate is times 30, that's the maximum. Labor Commissioner's office is pretty backed up, last I was aware. So an attorney might be a little faster, but you can do both.
Okay. Is it legal for my employer to force me to work through my lunch break?
Not unless they pay you a meal period penalty. So no, not without penalty.
Okay. Now, and it's important to note this is for hourly workers, right? Salary workers don't get lunch periods.
Salary workers are not entitled to a meal period, right?
And so we hear a lot of times, say an employee works at a gas station and they're the only ones there. And the boss says, no, you can't take a lunch break because we have no one to cover you. That's illegal, right?
There are certain types of work where you can have what we call an on-duty meal period agreement, but they still have to pay you for that time. If you don't have a valid on-duty meal period agreement, then they have to pay you 1 hour penalty for missing your meal period.
And let's say an employee says, I don't want lunch today. An employee can't just willy-nilly decide they're not going to take a mandated lunch, right? That has to, if that were to occur, that would have to be agreed upon with the employer and employee and in writing, correct?
They actually can voluntarily waive a meal or rest period.
Really?
Yeah.
And so an employee cannot be forced to take a lunch period?
Correct. The legal standard is not that the employee has to actually take it, but the employer has to make it available.
Interesting, because that brings up in my mind, could that get in a tricky situation where the employee says, you know what, I'm not going to take a lunch break today. Boss says, okay. And then the next day, the employee says, hey, you didn't give me my lunch break yesterday.
Employers claim that happens all the time. I'm generally skeptical that most people would want to skip their lunch break unless they were just overworked.
Yeah, I guess the only reason to skip your lunch break would to be if maybe you could either make a little extra money because that lunch breaks are unpaid, correct? Or get out earlier if you can kind of backload that to the end of the day.
Right, and that's what employers typically will claim.
Okay. And this is one of the biggest things of confusion online, which is when do lunch breaks have to come for hourly workers?
They have to come before the fifth hour of work. So if you start at like 8 a.m., you'd have to start your lunch before 1 p.m. or by 1 p.m. And then they have to be 30 minutes uninterrupted.
Now, this is where the confusion comes in. It's before the end of the fifth hour of work, is it not?
It's
So technically before the sixth hour of work.
No, it'd be before the one. It'd be by 1 o'clock if you start at 8, for example.
If you start at 8, so first hour is 8 to 9,
Hmm.
then 9 to 10, 10 to 11,
Mhm.
11 to 12, 12 to 1. So 12 to 1 is the fifth hour.
Right.
So it has to, so that the end of the fifth hour is 1 o'clock.
Correct.
So it's before the sixth hour.
Yeah. Yeah.
Okay.
Yeah. That's right.
This
We're saying the same thing.
Yeah, we are. It's just you'd be shocked on how people literally get in fights in our comment section saying, no, it's before the fifth hour. And it's because of, and I actually read the court case, and it's because the language, even in the court case, says before the end of the fifth hour. And I think what counts as the end of an hour, it gets a little confusing.
Right. Yeah. Yeah. When you actually say the hours out,
Yeah.
it is like that.
But I think what's important to remember is, okay, let's say your employer made you do it before the fifth hour started. So by 12 o'clock, they can do that.
Absolutely. They can make you take your break pretty much any time in the first 5 hours.
So there's no rule on how early the lunch can be, only how late it can be.
Correct.
Correct. Can my boss force me to work overtime?
They sure can. Yeah.
And there's no limits to the amount of overtime I can be forced to work.
Not under law, typically, no.
Wow. Isn't that kind of crazy?
Yeah, if you have family obligations or things like that, it can be really tough. You can have mandatory overtime, though.
And a lot of times we get the comment, well, no one can force me to work overtime. Well, that's true. Like the boss isn't going to physically force you to stay at work, but they can fire you for not working overtime.
Yeah, they can't change the machine, but they can say goodbye.
And what if I'm a student and I say, hey, I can't work overtime, I have class? Does the company have to abide by either my class schedule, or if I have a second job, does a company have to abide by my personal schedule?
No.
So when you're a student, you're only hoping that your boss abides by your schedule, but they don't have to.
Yeah, you're hoping your boss is cool, but they don't have to be.
They don't have to be cool. Okay, so I want to get into some questions directly from social media. We got one today that said, I'm so stressed at work, it's causing me to have panic attacks. Can I sue? So when does stress at work become illegal?
So it depends on the reason for the stress at work. If you have stress at work because of the nature of your job, that's a workers' compensation claim. You could, in theory, sue under the workers' compensation system. That's not what I do.
Okay.
What I do is if you have stress at work because of like illegal harassment, retaliation, or discrimination, if the stress is caused by that, then there's potentially a claim. Yes.
So if I'm stressed because I'm overworked or the boss is always, breathing down my neck, metaphorically speaking, that's probably not illegal.
Generally speaking, correct, unless the motivation's illegal.
Unless the motivation is illegal, unless they are doing an illegal act, then
Right. So if it's for discriminatory motives, if it's because of a protected characteristic, for example, or if it's because you made protected complaints about like your pay or something like that.
what if, second question from social media, what if I applied for FMLA and perhaps I'm either on it or about to be on it, but now my boss treats me differently because they know I'm going to be on FMLA? Is that illegal?
Depends on how severe it is, but it could be, yes.
Okay. Under what circumstances?
Well, I mean, if you are going to be taking FMLA leave and your boss, takes away all your projects, or maybe you come back and they just suddenly don't have work for you and they cut your hours, that's illegal if it's because you took the FMLA leave.
So there are retaliation instances with FMLA that could end up suing an employee.
Correct.
Employer.
Yeah.
If I signed a severance agreement, does that mean I can't sue my company?
Typically, yeah, you could not sue.
Wow.
because most severance agreements have what we call a general release, meaning I release any claim I have against the employer. And if you sign a general release, you're typically not allowed to sue for anything.
Sometimes we see, I was pressured to sign this severance agreement or some kind of agreement. What is the line there of an employee feeling pressured to sign something? Have you ever dealt with anything like that?
There's some types of contracts where you could get out of if there's pressure, but the pressure has to be pretty extreme. It can't just be like, we expect you to sign this. If you don't have the opportunity to review the contract, if they don't give you time to consider it, especially if you're over 40 and they don't give you time to review and consider it,
Mm,
there's special protections under the Older Worker Benefit Protection Act, OWBPA. So you can get out of it, but it's very unlikely.
okay. Suffice to say, if you sign a severance agreement, you're probably not suing your employer.
Correct.
Correct. Um, I just got fired. What should I do to protect myself?
If you just got fired and you think you may have a case, I generally think the best things to do are to hang on to any emails that you have related to your work. Maybe you copied yourself on some critical emails or something like that. You should write down a timeline of what happened to you, who did what when. Um, Contact to the extent you have friends at work or something like that, and just get their take on maybe what happened. And then you should probably contact an employment attorney.
Right. And when it comes to getting witnesses, do you find that coworkers are usually pretty willing to give statements? Because are they putting themselves in danger by giving witness statements, or do they have protections?
They are definitely putting themselves in the crosshairs if they give a witness statement. I typically recommend that my clients not try and get witness statements themselves. I'd rather do that on my end or with a private investigator. But people who do provide statements or declarations, affidavits type things in support of a claim of illegal activity, they are protected by the law as well.
Okay. And you can sue your employer while still working for them, correct?
Yes,
Can they fire you for suing them?
they can, but not legally.
Okay, so that would count as illegal retaliation.
Correct. Yeah.
Okay, so have you seen employees sue their company and continue to work for them?
Yes.
It
Yes, I have.
happens.
Hmm.
Wow, and because the company cannot legally do a negative recourse at you for that.
Right. Yeah.
Okay, wow. And last question, along with illegal retaliation. If I say I'm giving my 2 weeks notice today and you say, "No, today's your last day, you're out of here." Is that illegal retaliation?
No.
No. And the and why?
Well, because it's not an illegal reason. There's no protection. There's no guarantee under the law that you get 2 weeks to leave your job. If I don't like you, I could quit tomorrow, or right now during this interview.
Please don't. And since I initiated the resignation, that's why it's not a termination.
Well, I mean, technically it would be a termination, but it's not an illegal termination.
Well, that often begs the question, and I know you don't work for EDD and you don't deal with unemployment claims, but could that hinder getting unemployment benefits if you quit, but then were fired?
It could.
It could.
It could.
Okay, but it's hard to say.
It's hard to say. I don't deal with unemployment too often.
Right. Well, to finish up here, is there anything else you want to say to the employees who are listening or watching? Anything? What can they do to protect themselves, or what should they be looking out for moving forward?
If you think that you're being subjected to illegal harassment or discrimination or retaliation, you should keep notes. That's one of the best things you can do is keep a calendar of what's happening when, who did what, because one of the worst things that happens is, people get fired, something bad happens, and then you get into litigation a year later, 2 years later, 3 years later, you don't remember a bunch of the details.
Right.
And that's one of the hardest parts as an attorney to try and deal with is when your client can't remember their own story.
Wow. Right. So do whatever you can to make sure your story stays straight for years to come.
Yes.
Great tip. Well, Brandon, thanks for joining me.
Thanks for having me.
Relatively painless first episode, I think. And thanks everyone for watching and listening. Again, drop your questions to heart@d.law. We'd love to answer them here on the pod. And we'll see you next time for Heart of Employment.